Well, first of all, I would like to mention that I really appreciate this invitation from the Hague Convention and the Permanent Bureau of the Hague Convention, and also for the Hong Kong Special Administrative Region. Has been so far a really good conference, and I really congratulate all for this organization. About my presentation, it's related with mandatory mediation under the Chile law. But I would like first tell a little bit about the current status of child support conventions in my country. First of all, Chile has not ratified yet the 2007 Hague Convention. However, we have been working hard in that convention. It was reviewed by a working group composed by attorneys from all members from the Ministry of Foreign Affairs, Ministry of Justice, also from the Supreme Court, but also from attorneys from my institution, which is the legal aid institution of my country. We are a service which is part of the Ministry of Justice, but we have like a separate administration. Why we were working in that group? Because we are the central authority of Chile for the New York Convention. So it's obvious that we have the background and experience to mention or to have something to say about what are the pros and the cons of for Chile if we eventually ratify that convention. We are very hopeful about that our government is going to take the decision to ratify this. First, to send it to the Congress, but to do that, to move forward and do that, how you say, step. We believe that we need like a political how you say, decision in order to give a priority a subject like child support, which is not so important sometimes when a government has more other issues in the public eye, like I don't know, criminal rates and that kind of things, which are always have more better political outcomes instead of family law issues. In the meantime, we have the New York Convention, and as I said previously, we are the central authority for the application of that convention. We have to say that we are not only an administrative authority. We are a little bit different from the majority of the central authority of this convention because we are also mainly in the capital area. We are the attorneys who go to court and represent the parents of the mother who lives abroad. So we have both sides of experience. We deal with the administrative task, but we also go to court. We file a lawsuit, so we know about the procedures. Saying that, we have to say that our family law has an article 103 who established that in three matters, family matters, it's mandatory the previous mediation, which is in maintenance, custody rights, and visitation rights. this mediation is conducted by private mediators who has been enrolled in a registry in the Ministry of Justice. And once the parties go to these mediation sessions, or not, may not, the mediators provide a certification to prove that the mediation hasn't arrived to an agreement. With that document, you just then you can go to court and file a lawsuit about child support in this case. But then the problem arises: what to do in cases of international child support request? Because we have, of course, a lot of requests from our neighbors, country neighbors, but there are also a lot of requests from child support from countries absolutely far away, like Australia, for instance, or some other countries where there's a huge amount of Chilean people, like Spain or Sweden, which for political reasons has to move like before the dictatorship or after. Well, what we have done in order to try to solve that situation, the attorneys of the Central Authority start to, at the beginning, because this law is from 2005, just 10 years ago, the family court start to, at the beginning, to dismiss the petitions, the requests, over to declare inadmissible because they don't comply with this previous mandatory mediation certification. And by way of appealing to the courts of appeal, so the superior courts of these first instance courts, we start to get favorable decisions, and little by little the different courts of appeal of our country start to revoke the decisions of the family courts and say it's okay. This is an issue who cannot be subject to mandatory mediation because it's in most of the cases it's impossible, and the mediation has some characteristic which implies the attendance of both parties personally, because it's not the same that some others alternative dispute resolution mechanism. So we have some, just for like examples, I'm going to mention two decisions briefly. One of the Santiago Courts of Appeal said, it's a kind of translation. According to the Convention on the Recovery Abroad of Maintenance, it is necessary to eliminate all the obstacles for the exercise of maintenance rights. In the case, previous mandatory mediation has become an obstacle for the exercise of the mother's right on behalf of the children and the custodian of the name of the children who are abroad. So, this was one of the first decisions where Court of Appeal understood which it's impossible to continue requesting mandatory mediation. We have, and this is important because it's in the capital area of our country. We have another decision, which is from Valparaiso Court of Appeal, which said something similar. The previous mediation in family issues does not facilitate obtaining child support because, in this case, the grantee or claimant lives abroad in Argentina, and this special circumstance does not allow both parties to participate in a mediation process within a reasonable period of time. His in this case, the court was a little bit more open to have mediation, but here the important issues for that court was the period of time, reasonable period of time. After that, we start to include in every our lawsuit some request asking the family court to grant an exception in this kind of cases and accept to process a child support request in international cases without request mediation. But it's important to mention that in our country there's no case law, it's not a precedent-based system, you know. Every court is independent, and the decision of a superior court it doesn't imply that they always have to rule the same way. In every case it's going to be different, but at the end most of the family court understood that it's a little bit you know, unconductive, you can say, to keep on saying that mediation has to be mandatory in this kind of cases. And finally, I want to stress that we are not against mediation or alternative resolution dispute mechanism. Why we always are opposed to this mediation? Because in our legal system we have another opportunity to reach an amicable solution, which is at the beginning of the trial. We in Chile have, for this kind of matters, we have an ordinary procedure, which is oral, has two stages, which is a preliminary hearing and then a trial hearing. And at the beginning of the preliminary hearing, the judge has to call the parties to conciliation. And I have to say that about 50% of the cases of our incoming cases, child support requests from abroad, ends at this very first stage of the trial. You know, most of the I believe the 50% arrives to an agreement about child support. So we are not with the mediation in this kind of cases, but we are very with the conciliation in the first stage of the trial. It is obvious that we need to modify our law, family law, but in the meantime we have found through the attorneys of the central authority this practical solution which has been working not bad at all. So thank you.
Now back to the north.